Yes, Lordship, I beg to mention for listing of one appeal, Lordship. For admission, for orders, Lordship. IA is pending, Lordship, since 2023, Lordship.
Okay, when do you want?
Any date next week, Lordship.
Okay.
Deeply obliged.
I beg to mention item number 10 and 11. I am for the 10, Lordship. 11.
You're for? You're for item number 10. Given a memo
Yes,
yesterday. What is it?
I pay for password for a day.
It's for orders. Have you seen the records? Why is it for orders? You see the record, check the records. It may be for steps. Very
No,
small
Lordship,
steps.
majority I has been dismissed for final disposal.
Let you check the records, then come back.
Lordship.
With you consent from the other side, I would like to mention item number 13.
1-3.
1-3.
Yes, what is it?
But I could not find the objection
You're for whom? The state?
respondent.
No, matrimonial.
Item number?
13.
Oh, 13 is a matrimonial appeal. Okay, okay. Yes, madam. Oh, what is your name?
Authorised.
On the request of Ms. R. Hussain, learned counsel for the respondent, matter is adjourned by 2 weeks to enable her to file. What do you want to file?
Points that
In a mat appeal, where is the question of further pleadings? You can take time for instructions, but there is no question of filing pleadings in an appeal. We are going to decide the appeal on the basis of the records.
Anyway.
There's no provision for filing pleadings in an appeal. Unless some new thing has come out in the affidavit. You can seek time to have instructions properly, but that will not be the order. Allowing you to, will not set a precedent like this, wrong precedent. What is your name?
Saud.
A?
Saud.
Oh, EU Saud. Heard, don't write that. Heard Miss EU Saud, learned counsel for the appellant. Also heard Miss R. Hussain, learned counsel for the respondent, who has, however, prayed for some time to obtain instructions. Para, list after a week.
Okay.
Item 1.
Lordship, the matter has already been admitted on 23/10/24. However, there were two appeals which are disposed of, analogous matters, Criminal Appeal 196 of 17 and 204 of 17. A paper book was prepared in that appeal. We may be furnished with a paper book and the matter may be listed for hearing.
The paper book in Dhanjit will cover your case.
My lord, same, it's common judgment.
Okay. And those appeals are pending.
No, my lord, they are acquitted. This person never filed this appeal. Now we are filing.
Okay. Heard 3 D.K. Bhattacharya, learned counsel for the appellant. Also heard 3 R. Kaushik, learned additional PP Assam. Para. This appeal, although this appeal has been listed in the admission column, comma, it appears that wide order dated 23/10/2024, the appeal has already been admitted. Full stop. Sri Bhattacharya, the learned counsel, has also informed that the judgment, that the impugned judgment was the subject matter of 2 separate appeals, which appeals filed in this court, which have already been disposed of. And in those appeals, paper book was prepared. Full stop. Copy of the paper book has also been tagged with the records. Full stop. Let copy of the same be furnished to the learned counsel for the appellant, whereafter appellant, full stop. The appeal may be listed for hearing in its turn. Okay.
Obliged.
The conviction under Mr. Bhattacharya under?
302.
Oh, no POCSO involved.
No,
Okay.
302.
So private respondents, those are not there. Okay. How many years you are behind the bar?
My lord, judgment was of 2016.
16.
So
Okay,
till now-
then we can fix a date. Paper book is there. In the third week of March 2026. Okay.
A paper book may be furnished.
We have set paper book.
Obliged.
You coordinate with the office, get the paper book early.
Item two.
May please, your Lordship, can the matter be adjourned for a day, Lordship? Mr. Kyal has some personal difficulty. The matter could not be prepared.
Okay, yes, tomorrow or Friday?
Friday,
Friday.
it can be detailed.
On a request,
My lord, can it be on in the first week of March? Instead of Friday.
you tell us that it's only for admission
Yes, my lord.
It's for admission.
and
It's
25
not been
matter for
admitted,
admission, let it be on Friday.
Lordship.
On a request made on behalf of Sri S.C. Kyle, Learned Council, Learned Senior Standing Council, CGST, matter is adjourned to be listed on Friday.
Lordship.
Sri S. Mitra, Learned Council for the respondent is present.
Much only.
Item three.
Please, your Lordship. The delay was condoned in this case. Clean notice means food.
Poxo matter.
Poxo matter.
Yes, madam.
My senior is, Lordship, my senior is on the way. So,
Are you there on record? What is your name?
Monica Das.
M. Das.
And
Admit.
yes, yes. Come on.
We'll admit this. Heard, Miss M. Das. Same power, huh? Yes, so. একদম একই হবে admit call for the record বাকি state of some payment থাকে second to through the office of the that's it into working days list after same okay. I for what
Suspension.
POCSO will issue notice here okay
I think here also some mistake.
Hmm.
Okay.
in the application I is for application
389 of BNS should be 430.
photo they have corrected here
Corrected, right?
corrected
My copy.
and without there being any signature. I don't know how these corrections have been done. Madam, this is not the way to correct. If you correct before presenting, you have to put your initials. Okay, on application, huh? This is an application under section so and so for grant of bail. And so the connected appeal has been admitted today, huh? Issue notice.
Informant, respond number 2 is a minor actually. Informant is last week.
I mean,
Informant is last week.
it is
R2 is a minor. Informant also, right?
Term of issue notice, returnable by 6 weeks. RR Koshik 1, 2, same procedure, okay? It will be returnable question, returnable 6 weeks, okay?
We'll file objection.
Yes. By the next date, comma, the respondents may file objections. Full stop. It is also made clear that since the respondent number 2 is a minor, comma, she may be represented by either by her guardian or the informant may also enter appearance on behalf of her. Okay, yes.
May I please, your Lordship, this is a statutory appeal, Lordship.
Item number 5.
Item 5, Lordship. He was convicted under section 6 of POCSO Act, Lordship, for 20 years.
So,
For life, your Lordship.
302.
302.
Okay. As what her pronoun?
Connected district litigation and readability.
Yes, application.
Lordship, it
What-
should be had.
What is this? We have already told.
Lordship.
Please take care of this.
Lordship, I apologize.
You
for-
are a seasoned person if you
Lord.
not, and there is no requirement to address. Why are you addressing in appeals?
Lords. So many appeals are thrown.
Same, huh? As both are put. Admit call for the দুটা আছে appellants আছে আৰু is it under what POCSO?
No, your lordship, 302, your
So
lordship.
number 2 is not true.
IPC.
Number 2 is not true, huh? It is 302. Steps for service of notice upon the respondent to in the manner prescribed. Steps within 2 working days. Okay. আৰু application to very good notice দিব. Notice will make a returnable date on the
Lord.
application. You'll have to take steps. 6 weeks করে দিব. Okay.
Lordship, this may come up along with the connected appeal, your lordship,
There's-
42.
Which one?
41. Criminal appeal 41 of 2000.
Admitted.
Out of the same judgment.
No, that has been admitted.
Admitted, your lordship. That's.
It has been submitted in the appeal letter that against the same judgment, criminal appeal 41 of 2026 has been filed and has been filed in this court, which is pending. Para list along with
Lord.
Objection would be pending.
yes, our application of by the next date. Objections may be filed
Lord.
by the respondent.
May it please your lordship, this is a statutory appeal against conviction for 20 years. POCSO lordship.
First copy to certificate. Oh, it was
Yeah,
certificate.
please, Your Lordship.
You know, can you certificate to? It was certificate to pay holy sir. Yeah. It was certificate. You know, pay honey. Huh? Put to. The last protocol of it. Huh? You know, can you put it to the number? No, put it to the trahiri. Put it to the trahiri, not a thing, believe me. Put it to the. I'm subordinate. Yes, Mr.
May I please, Your Lordship? Statutory appeal under section 21(1) of the National Investigation Agency Act, my lord. I have been convicted under section 18, 38 and 18B of the UAP Act, my lord. And I have been convicted, a sentence for life.
This is under 21.
Under
Section
21.
21, okay. B Prasad. Huh? It was section 21 of the National Investigation Agency Act, right? Bele ko ba, ito? Baki sab kore against so and so and so. Admit call for the report. Your name?
Satyanarayan.
Satyanarayan. You're the PP?
The DLA.
Okay. Oh, you got the DL and I put record logo. For the hearing. Baki kine call for the record. List after receipt of records. That is a private respondent night. Okay. Lodge. We have admitted.
There is an IA also. No? Sorry. Again, 22 and 23 is something.
May it please your lordship. Lordship, in this PIL, we have read for construction of Anganwadi center, your lordship. There are 2 PIL in PIL 23.
Those were listed earlier. These are matters pending since a long time.
Yes,
What is
Your
the
Lordship.
present stage?
Present stage, I think the
Present
respondent
stage,
will update.
Mr. Doctor, are you appearing? Because last time they had sought time. On 17/12/2025, the matter was adjourned on the behest of the petitioners.
Corrected for
Your
relocation.
lordship, may I kindly see,
This one.
order dated 24/6/25, your lordship.
Yes, we have seen that.
The respondent was supposed to file
Have
affidavit.
you filed the affidavit?
No, they have not yet.
Which respondent? You are whom? But
Petition they have filed, your lordship.
who are 2, 3, and 6?
I found for 2 and 6 in the government file.
You have filed.
Government has filed. Yeah.
4 and 6. Okay, doesn't matter. 2, 3, and 6 were supposed to file affidavit.
Yes, your lordship.
Affidavit has been filed.
Yes, 1, 2 and 6.
Then it will be okay, I think.
Your lordship, they,
Have you been served with a copy?
The big copy number, it is not exceptional.
1, 2, and 6, they have filed also. In fact, in paragraph 8, they have admitted that there was no such project under ICDS, your lordship. Page 20,
Now, if you are ready for a final disposal, we can hear you and the other side. See, substantially, the observation of this court has been complied with. 2, 3, and 6 were required to file an affidavit.
Yes, your lordship.
1, 2, and 6 have filed. That will cover the issue. If you are ready for the hearing, we can hear you.
Lordship may kindly fix for another date.
Another date.
Yes, your lordship. Yes.
Mr.
Absolutely.
Doctor, we are still asking you. Will your affidavit filed by the other respondents cover the present requirement?
Perhaps, because I'm.
Perhaps will not do, perhaps will not do.
I'm calling some whole government. So they have filed.
You have the instructions. See, who has filed, that is not the primary concern. Concern is whether the issue has been dealt with. Whether your dealing will accept or not, that's a different matter after hearing Mr. Chakma
Yes, your lordship.
on the other side. But we want your response in terms of the court's order. You get back to us. Then since he is asking for a date, we can have it for admission hearing on a date fixed.
Yes, your lordship.
But you just get back to us immediately. I mean, tentatively at a good rate. We are tentatively passing the order, subject to what instructions you have. Heard. You are Chakma,
Yes, your lordship.
SK Chakma,
SK
learned
Chakma.
counsel for the petitioner. Also heard. Sri S. Datta, learned standing counsel, PNRD, and Sri S. Das, learned counsel for the APDCL. Madam, you are also there. For whom? RKD, L. Devi, on behalf of RKD Chaudhary, Deputy HGA. Full stop. Sri Datta, the learned counsel, learned standing counsel has submitted that pursuant to the order dated 24/6/2025, comma, an affidavit has been filed by the respondent numbers
1, 2, and 6. your lordship.
1, 2, and 6, which would cover the issue arising. Full stop. Para. 3. Chakma, the learned counsel, prays for a date for consideration of this matter. Para. List for admission hearing on when? Today is 18. We can have it on 5th of March. Is it okay? 5th of March. And Mr. Datta, come back immediately.
Yes.
This is the tentative order. If you have some other instructions,
Fine.
please let us know.
Fine.
I'm obliged, your lordship.
Easy.
Same order.
There are two orders, Mr. Chakma, both same.
Yes, your lordship.
One order will go, I think. It will take. মুগলি কালি নোট খিনি আছিলে এইটো মেটাৰত এই কালি আধা ঘণ্টা হ'ব না এইটো নোট ইয়াতে অহা নাই ইয়াতে আছে না ঠিক আছে
No, she received the report. Immediately.
item 9 what is it
And we have filed an
it is
objection.
for orders
Service reports.
what is this IM Mr. Chaudhary
Lordship,
IA for
I for suspension of sentence and consideration of bail, Lordship.
conviction
Under PROCEEDINGS, Lordship, for subsection 2, Lordship.
it has been served
Yes, my lord.
served
Yes.
then we since nobody has appeared we can appoint an legal aid counsel
Lordship.
I leave it to your lordship's discretion. Observation of the other court is that say they should come up before the legal service authority and inform that we don't have the means. Since it is already informed our notice, my lord. Since they have not come up, so in the event of the matter, it's up to your lordship.
Now we'll appoint a legal aid
Fine.
counsel. Let there be representation.
Fine.
Okay. When is this report of? To a long time.
29/11.
24.
Yes.
24.
3/12/24.
Okay.
Last 25 would have been last.
Three, I use Chaudhary learned counsel for the applicant, also heard Miss B. Bhuya learned APP, who has placed before us copy of the report issued by the concerned officer in charge, Borpeta PS, regarding service of notice upon the respondent number 2, correct?
Yes.
Full stop. Since the respondent number 2 has not appeared, has not appeared, and the conviction and sentence being under the POCSO Act, comma,
Lordship, something is wrong somewhere. As regards in the report, my lord, contents the lordship, I have overlooked, my lord. ইয়াৰ দ্বাৰা আপোনাক জনাও যে উপৰোক্ত উল্লেখিত আপোনাৰ গোচৰটো তদন্তক্ৰমে পৰকীয়াজনৰ বিৰুদ্ধে পলাতক আসামী, I don't know what basis they have given this report.
Well, this is regarding the charge sheet. No, I think he has written it.
Please have it declared.
He has written it wrongly, actually.
Maybe. Lordship, I'll get a fresh report from the authorities concerned.
He has written it
but
wrongly.
is there any reference of the High Court's case?
In our.
No, not in our, the notices. Notices are not in connection with High Court case.
Yes, so it will be necessary.
321.
192, PNSS. 192 to have given one.
Uh,
Right?
93,
necessary.
21.
I think you get a fresh report.
My lord.
I think his intention was correct to give you the information, but because this date, 9/12, it is after the filing of the present appeal. And it appears that pursuant to your communication, this has been responded. But the contents, as you said, are on a different context.
My lord.
It is not in context of appearing in the appeal. Okay, all
Yeah,
good.
get back.
Okay. Heard three. I.U. Chaudhary. Also heard Miss B. No, full stop. Oh, no, learned additional PP, Assam, full stop. Though Ms. Bhuya, the learned APP, has submitted that a communication has been, that certain documents have been furnished to her pursuant to the communication dated 29/11/2024, comma, the contents of those documents do not appear to be in the context of the present appeal. Full stop. She accordingly prays for some more time to get the appropriate instructions regarding service of notice upon the respondent number 2. Para? In view of the above, matter is adjourned to be listed after 4 weeks.
Any date, Lordship, after.
We'll give a date, after 4 weeks. List on 18, no? 18. On 20th of March
20.
20. This you can give a photocopy. This you can take,
Got copy.
but this is the original.
No.
Huh?
My
No,
junior-
originally you are supposed to retain.
No, with me, there.
But the signature,
Yes, my
madam?
lord, all the pages she has signed like that.
oh,
The
is it?
junior has signed.
Deeply. I checked, my lord, service is complete. Paperwork is also ready, Lordship, my lord, matter is ready for final hearing.
Is it?
Yes.
Conviction under
POCSO, Lordship.
What about the respondent number two?
R2, they have entered the appearance. So R2.
Mr. You are there.
No, hearing the-
You are for the respondent number two. Okay.
their name is shown.
Okay. Yes. Oh, heard your D. Gogoi. Heard Sri D. Gogoi, learned counsel for the appellant. Also heard Miss P. Bhuya, learned APP. Mr. Prasad? Connected? Connected.
Two
Uh,
accused persons.
Also heard Sri S.K. Chakma, learned counsel for the respondent number two in a criminal appeal
340,
340, and Sri B. Prasad, learned counsel for respondent number two in
332.
Criminal appeal 332.
332. The paper book has been prepared and the matter is ripe for hearing. Conviction under what? POCSO? List for hearing in its turn. Okay. On their turn, Dudra Setu, on their turn. Come on. Arun. This will be in item numbers
10 and 11.
10 and 11.
May it please your lordship. My lord, this honorable court was pleased to direct for ossification test of the
In the next item 11, madam, no, there was no representation.
This was not.
Anybody connected? No, was there anybody?
Yes.
Okay.
It's also there.
Okay.
I don't know whether she is.
I do not know. That is what we are, but doesn't matter. Doesn't matter. We have not passed any orders which will be prejudicial. Yes, Mr. Bhuyan.
Yes, my lord, by this court's order, my lord, this appellant, my lord, who has been convicted under 302 was sent for, my lord, ossification test, my lord, by order dated 4/4/2025. That report has, yes, 6/5. And that report has been submitted before this honorable court. On the last occasion, my lord, copy of the report has been furnished to us. And from the report, it appears, from the opinion of the doctors, that the age is above 40 and below 50. That has been the finding.
Wide
And-
range.
Yes. So if that is so, my lord, if we take the lower age limit, then at the date of incident, he will be about 14 years old.
But range is too high. 10
That's
years.
2 years, my lord, difference. There is a judgment of our division bench of this honorable court
10 years.
with regard to that on a PIL that
No,
was
10 years, you have said.
10 years.
10 years.
Here also it was 10 years. So, and that benefit was given to the, my lord, here in this case,
40 to 50.
para 23 onwards, my lord. And this is governed by, my lord, 2000 JJ Act, my lord, and the rule of 2007. Paragraph 23, my lord, will be important, my lord. Here also it was 10 years, my lord.
Such a wide range is usually not given, right? Usually not given.
Difficult, my lord.
Usually not given.
Huh.
Anyways. Thirty to 40 years.
Too indeterminate. Ambivalent. And in that case, there were other factors also
Yes.
in paragraph 24.
Yes. Here in this case, my lord, the other factor is with regard to, my lord, that my lord, in 313 it has come on record, and even one of the defense witness has been examined, and they have also stated as such. My lord.
Just a minute.
Not in this case, my lord. I'm sorry, I have mixed up with the death sentence reference. 313, yes. To death reference, my lord, mix up with. Yes.
Do it on a regular date, because
Yes,
this
my
bench is a temporary, we are on the midst of because this will require some time.
Yes,
If you insist on this, we'll have to consider it properly.
yes, my lord. Yeah.
We can have it day after tomorrow,
Yes, my lord.
day after tomorrow.
Otherwise, there are judgment.
No, that is why
Yes.
this will require some consideration. 10 years range is a wide enough range,
Yeah.
and this judgment, it has not, in fact, it has not accepted in total. The judgment has taken into consideration the earlier
Other
certificate,
relevant consideration.
corroborating materials, and have come to a conclusion.
Yeah.
Whether Mr. Bhuya would be able to make out a similar nature of
Yes,
case.
I will try to.
Heard Sri A.K. Bhuya, learned counsel for the applicant appellant, also heard Sri R.R. Kaushik, learned additional PP, Assam, Para. Sri Bhuya, the learned counsel has informed that pursuant to earlier orders of this court, the ossification test report has
Royal Court records.
been furnished, has been sent and is a part of the record. Full stop, para. List for consideration when? Friday or Tuesday, whenever you say.
Any day, my lord.
Next Monday. Monday,
Next week will be there.
next Tuesday. Okay, next
Tuesday.
Tuesday. Tuesday you are here?
My lord,
Okay.
yeah. Teshpur is there, my lord. Monday, le lo.
Wednesday,
Wednesday, my lord.
next Wednesday.
Yes,
good.
my lord, Wednesday. Deeply obliged. my lord.
Yes, Mr. Okay, same. Thank you.
Lordship 302, as TCR has been received.
You are a legal aid counsel.
Lordship.
Heard Miss B. Sharma, the learned legal aid counsel for the appellant. The appeal was admitted and records call for wide order dated 19/12/2025, pursuant to which the records have been received. Para. Office is directed to prepare the paper book and list the appeal immediately thereafter to fix a date of hearing. Sri R.R. Kaushik, learned APP is present.
Lordship. 15 is also same, only here TCR not yet received.
PCR is not received.
Not received.
Await this.
Heard Miss B. Sharma, learned legal aid counsel for the appellants. One appellant or two? More than
One.
the appellants, appellant. No,
One.
there are three more.
Was acquitted.
How many appellants are there? এটাই নাকি?
Same. Vicky Thapa.
The others had prefer another appeal.
No,
So
no,
here-
here only.
Here only one appellant.
এটা appellant, এটা ভুল।
Vicky Thapa.
The appeal has been admitted and records call for wide order dated 19/12/2025. Para. Office note dated 16/2/2026 reveals that TCRs have not been received. Para. Office to give reminder for requisitioning for early transmission of the TCR. Full stop. List after receipt of the TCR.
Obliged.
May I
Yes.
please, Lordship? Lordship, this IA is for suspension of contempt.
Item
File
number.
consent. They have filed objection already. PP has filed on objection. So these three, petitioners-
The paper book has been prepared.
yes, Lordship. Day before yesterday, I got the paper book.
You argue the case on merits? Okay. Judgment is of which year?
To 25,
25.
August 25.
Sentence to commercial quantity under NDPS Act.
Yes, Lordship. 21C and 22C.
What is the sentence?
Yes.
Do you remember?
20 years,
20 years.
20 years, Lordship.
You argue the appeal on merits.
Okay, আগতে এইখন
Heard, we have the appeal for hearing. Heard. Empath of learned counsel for the appellant, oblique applicant, also heard three. R. Kaushik, learned APC Assam. Full stop. The paper book has been prepared in terms of the earlier direction of this court. Para. We are of the view that instead of considering DIA, the entire appeal can be considered. Para, in that view of the matter, in that view, the appeal is directed to be listed for hearing. When?
Lordship,
Not immediately,
may
not
be-
immediately. There are appeals before you. In criminal appeals, that strict chronology, the strict dates cannot be given in the.
otherwise, Lordship, it will come in due course. So my IA ought to have been disposed of before that.
And will they have the IA and will dispose it of.
Yes, Lordship, yes. It will be better for me.
Okay. IA to, and then you write in the IA. We are dismissing the IA.
Yes.
We will say that paper book has been prepared. Okay.
Yes.
Heard applicant, huh? By this application. A prayer for, where is the IA?
IA 12225.
The present application has been filed under section 7 for suspension of sentence and grant of bail. Full stop. The connected appeal has been preferred against judgment so-and-so, passed by so-and-so, convicting so-and-so. The appeal was admitted by order dated 4/8/2025 and TCR was called for. Full stop. The TCR have been received and pursuant to a subsequent order dated 12/12/2025 directing preparation of paper book, the same has been prepared, copies of which have been furnished to the learned counsel for the contesting parties. Para, we are of the opinion that instead of considering the IA, the entire appeal is liable to be considered. Full stop. Para, in view of the above, IA stands rejected. Full stop. However, we direct listing of this appeal for hearing in the hearing of the appeal in the first week of May 2026.
Yep. May I please, your Lordship? Lordship, may peruse the last order, Lordship, 28/11/25. Instruction of
Item number?
17, Lordship.
Yes. TCR has not been received. Has not yet been, oh, okay. Heard Sri I.U. Chaudhary, learned counsel for the appellant, also heard Sri R. Kaushik, learned APP, para. As per office note dated 26/11/2025, TCR have not been received, para. Office to give urgent reminder for,
TCR is.
hold on. I see it. What I told? 26/11. Asani. TCR has been received.
TCR is there.
Oh, sorry, not the police. The learned counsel have learned counsel for the parties have informed that TCR have been received, and in this connection, office note, there is also an office note dated 17/12/2025. Para, office is directed to prepare the paper book and list this case immediately thereafter to fix a date of hearing.
Lordship. And IA is there, Lordship. IA,
What do you want in the IA?
Lordship, Lordship may produce the last order, Lordship,
Yes.
2011.
Yeah, we are supposed to take.
You filed the objection.
Objection not yet
Not
filed,
yet filed, my lord.
and instruction is awaited also.
You filed the objection
My lord.
in the IU, right? On Heard Sri IU Chaudhary, learned counsel for the applicant, para. On the prayer of Sri R. Kaushik, learned APP, further 3 weeks' time is granted to enable him to file the objection. List after 3 weeks.
Any date, Lordship, after 3 weeks.
You tell us,
Um,
list on
Second week of March.
9th of March,
9th of March, deeply,
not 9th, we'll have it on 12th of March.
Lordship, deeply over.
18.
Yes, madam?
May it please your lordship, the TCR has been received. Also, your lordship, steps were taken on the respondent number 2. Service completed.
You're a legal aid counsel.
Yes, your lordship.
So we have not received any instruction that.
This year, he said? Okay. Heard Ms. M.K. Brown, learned legal aid counsel for the appellant, as well as Sri R. Kaushik, learned additional PP Assam, para. Ms. Brown, the learned legal aid counsel has informed that PCRS have been received. And in this connection, we have also noted the office note dated 16/2/2026. Let the paper book be prepared, whereafter the matter is to be listed for fixing a date of hearing. In the IAU, right? Heard Miss Brown, the learned legal aid counsel for the applicant, para, on the prayer of Sri R. Kaushik, the learned APP, further 3 weeks' time is granted to enable him to file objection. What about there is a private respondent
Yes, your lordship, but.
served
yes, your
or not?
lordship. Informant.
Served.
I had taken steps.
Instruction not received yet.
Instructions are not.
He is also required conviction under
Your lordship.
POCSO.
POCSO,
Okay,
yes.
the learned APP is also directed to obtain necessary instructions with regard to the aspect of service of notice upon the respondent number 2. We give a date, madam?
Yes, your lordship.
Same date, huh? List on 80.2 Disseminate Metro. Well, 13th of March.
Obliged.
Until 19.
May I please, your lordship. Lordship, there is a delay of 84 days in the connected appeal. Lordship. And conviction under 302, lordship.
Okay, we issue a formal notice,
0 to 84 days.
84 days.
84 days.
Heard Miss L. Devi, learned legal aid counsel for the applicant who has filed this application under Section 5 of the Limitation Act 1963 for condonation of delay of 84 days in preferring the connected appeal. Full stop, the appeal has been preferred against the judgment so and so under so and so. File. Sarah? Miss Devi, the learned legal aid counsel, comma, by referring to the averments made
and
in
three.
paragraph
2 and 3, lordship.
2 and 3 has submitted that due to reasons beyond the control of the appellant, the delay has occasioned, full stop. She has also reiterated that there is no negligence or laches in preferring the appeal. Para. Ms. Bhiya, the learned APP, has fairly considered that there will be no serious objection to the aspect of condemnation of delay, and the appeal would rather be contested on its merits. Para? The law is settled on the aspect of dealing with an application for condemnation of delay, wherein there is a requirement to have a pragmatic and justice-oriented approach. We have also noted that the appeal has been preferred from jail through a legal aid counsel, and the reasons cited appear to be bona fide. Para, in that view of the matter, the delay of 84 days in preferring the appeal stands condoned. I accordingly stands allowed. The appeal may be registered and listed for admission.
Obliged.
May I please
Mr.
allow
Talukder?
appeal against conviction under 376.
Why it is for orders?
I is pending lawsuit. Paperwork is also ready. They have filed their objection.
You
Lawsuit
argue
only
the case, we can have the paper.
14 years of conviction. Lawsuit only see the evidence of prosecutings and the mother
14 years.
and the doctor. Only 3 witnesses have lawsuit kindly sit.
Conviction under?
376 2F for 14 years.
Service is complete, and
Service is
none is
complete.
entered appearance.
Amicus may open for.
Who is in it?
Lawsuit kindly see the last order. I forgot.
Lawsuit 19/2026 order. Oh, 2025.
No.
1/6.
There is no appearance by the
Yes,
respondent.
But it was served.
But
So,
service is
lawsuit
complete
will
and is
appoint
observed in the
We will
earlier
appoint
order.
an
amicus.
amicus. Who's there? List? Anyone? Can you suggest?
Lovely lady.
Seek an appeal.
Let us have somebody who has not appeared for a long time.
Lodge.
Nice.
We can have serial number 30, Anup Mrinal Datta. We have not seen in the court for a long time. At least he'll have to come now.
Also.
Okay. Heard Sri D. Talukdar, learned counsel for the applicant appellant, as well as Ms. D. Bhuya, learned additional PP, Assam. Para. It appears that though the notice upon the respondent 2 has been duly served, there is no appearance till now. Full stop. The conviction and sentence being under the POCSO Act, we are
Not
of the
POCSO, 376.
376 of the IPC, we are of the opinion that
2F.
an amicus curiae be appointed to represent the respondent number 2. Full stop. We accordingly appoint Sri Onu, slide number 3, an empaneled amicus curiae to act as the amicus in this case for the respondent number 2. Let a copy of the paper book be furnished to him by the office. List this case for list this case for consideration after 2 weeks by reflecting the name of the amicus curiae.
Lordship, we don't
You-
have a paper book. Maybe it was served.
Coordinate with the office. He has been served. differently.
I have been served.
Mr. Talura, you might have to serve a copy of the IA on the amicus,
That's-
because if you are pressing on the IA,
I'll serve.
paper book will serve entire thing, but still then he should be equipped with the copy of the IA also.
Lodge.
Money di buku, ha?
Until 25.
Lordship, I'm so sorry. Yesterday could not appear.
Okay, we have accommodated
Ask me
today.
back.
Today we hope that we'll be completing very soon.
Yes, yes.
We want to dictate the judgment,
Why
complete
not?
everything.
Lordship.
We don't keep it.
What I've gathered from
Eh, itu ni kan apa ni? Apa ni? Eh,
Should I proceed? What I have gathered from the submission made by my learned friend, that evidence of two eyewitnesses, Your Lordship, is not believable, is not trustworthy, Your Lordship. They cannot be taken as an eyewitness. And as regards the confession statement with the accused person, since the trial court has already discarded, Lordship may not take into account. And as regards GD entry, Lordship, probably he has made a submission, my lord. Because GD entry was made and then thereafter FIR has been lost. So subsequent FIR, so on the basis of which the investigation has been progressed, whether it can be taken into as an FIR. And regarding what plea have you taken? Delay in lodging the FIR.
Recovery.
Recovery, yes.
Recovery of the
Yes. So
That is
first
not-
I'll take your lordship to the evidence of 2 and PW 10.
Okay.
2 Rubul Hussain is the son of the accused, this one, the victim, your lordship. PW2, your lordship. Rubul. Somewhere he is written as Rubul, but in his signature.
Signature also not very, you cannot decipher from the signature. Can be Ruhul, it can be Rupul.
Lordship. Lordship, although he has projected himself to be an eyewitness, Lordship, I have read, maybe I have missed something, but Lordship, whatever he has adduced before the learned trial court, whether his testimony is believable, because he being an eyewitness and son of his father has been attacked, he's just sitting like that. His conduct is somewhat not.
But he is not he's a young boy, 22 years only.
20 years old, my lord.
22 years.
22 at the time of deposition.
Yes, he was at
Because
the
the
time.
occurrence is 2015.
Yes, he was not, he was a young tender boy at that time. That,
Let us read it slowly, your lordship.
yes.
I might have missed something. Page 12. On 26/7/15 at about 5 p.m., I was on a national highway at a distance of 3-4 nulls away from the place of occurrence. 1 null is about 200 square meter.
No, he has said 1 null is 12 feet.
12.
No. Google says, yes, 200 square meter.
200 square meter.
Yes, 1 null.
No, that would be of an area. Null in terms of a distance, he's saying.
Distance. To distance. 1 null.
Google says I am wrong, by
No,
It is a local.
we need your assistance on this because this will make a significant change,
Yes.
impact in the decision making. What is 1 null?
Lordship, I'll have a look on.
He says it's 12 feet.
Some
and-
Google.
And as per you have said, it is appears to be the area. We are not on the area. We are on the distance.
Distance.
Now is a very local term, right?
Term, my
Lordship.
They're not used in other parts of the country.
In Barak,
I am not aware, but it is in Borakville,
Barakville.
particularly in Borakville.
So, sorry.
Only a local land measurement unit used in Uttarakhand is equivalent to approximately 200.67 square meters.
No, it's not. It's not Nali.
Yes, it is also equal to 240 square yards or.
No, these are areas. We are on the aspect of distance. You write Nal and you write Barak Valley. Then you will come.
Maybe.
Yes, what is it? How much?
So na ki mane.
One knowledge goes to, as per his knowledge information, it's 12 feet.
One null feet,
Feet.
no?
It's
How
very-
many feet?
It's very specific to southern Assam.
One square feet of like, 2.160 square feet.
No, if the aspect of square come, it becomes a,
My lord,
for area, we are not on the area, we are on the aspect of distance.
square feet.
Like a furlong or whatever, inch or a foot or whatever.
Aisa, nali ulaise. One nali.
Nali will be different, null is different.
No, it's not showing.
It was saying it could solve, no,
It is for-
you don't know what it was. Pencil was it.
All in the earlier times, the bamboo pole was measured.
Something-
Yes,
One bamboo pole is one.
then it will be much more than 12
Yes,
feet.
yes, but that bamboo is of 12 feet. That is correct.
12 feet bamboo.
Yes,
is
yes.
One.
Yes, one null.
Two nulls.
3-4 nulls he has stated
No,
in his
it's-
Okay,
Eight.
then with 36 feet around.
36 or 50, that in between. 3-4.
3-4 nulls.
3-4.
And it is different, that's why.
Colloquially, they are using this term,
Lordship.
There may be another null in Uttarakhand, that's why
I
your
know.
square feet is.
Yes.
nali.
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 That is used for measuring the land in the local area.
Lordship may proceed. There was one pharmacy of one Altaf Hussain near the place of occurrence. At that time, I found Zakir Hussain Laskar, who was coming from Lalchera in a bike, and he stopped near the pharmacy. At that time, my father and my uncle Islam were there. Then the accused Zakir Hussain Laskar arrived at the spot with a dao, taking the same from his bike, and at first he gave 2 dao blows on the head of my father, and as a result, my father fell down on the ground. By that time, my uncle Islamuddin went to the pharmacy of Altaf Hussain. But the accused rushed to the said pharmacy and inflicted dao blows on him too. And thereafter, the accused came out of the pharmacy, and thereafter, the accused found my father alive, and as such, he also gave more dao blows on that neck of my father. And as a result, my father died at the spot instantly. By that time, many people assembled there, and then the accused left the place of occurrence in this motorcycle. Immediately after the incident, my mother and my brothers and sister came to the place of occurrence, and I told the entire incident to my mother. Thereafter, police came to the spot and took the dead body, and myself and others also narrated the incident to police. Exhibit 1 is the inquest report when exit so and so is my signature. My uncle Islamuddin was shifted to SMC Silchar, and for his treatment, who sustained cut injuries on his cheek, right hand, and back. My exhibit 2 is the list. Police seized on bloodstained white half ganzi, one bloodstained lungi, one bloodstained white Punjabi. Thereafter, the PM examination of the dead body of my father was conducted at Hailakandi Civil Hospital. When the accused was arrested, the concerned dao was also seized. Then cross-examination. My responsive submission is that from the examination chief, my lord, his father has been attacked. Lordship, he didn't make any hue and cry. His conduct, Lordship, I'll leave it to your Lordship's discretion. Let us read the cross-examination part.
See, there is one line on the, at page 12, from bottom, the sixth line, it starts with immediately.
Immediately
Immediately after the incident, my mother and my brothers and
Yes,
sister came to the place of occurrence. I told the entire incident to my mother.
yes. It's true. PW1 is also deposed.
Mm.
That she has been reported by PW2,
Too.
her son.
This is consistent.
This
He is a son
consistent.
of around 20 years.
Yes. 20, so I was while going through the evidences, I tried to see his age, my lord. 20 years old guy, lordship, will remain silent. His father has been attacked. His
He
conduct
has
will
not
be.
stated anything regarding that event track. He has not stated.
Yes,
Whether he.
Let
made
us see
event
the
track,
cross-examination.
It's not come from the.
my lord.
Different people again respond differently to
Yes.
trauma.
So my submission is that CW10, his evidence is reliable, my lord. His could not be shaken, my lord. So once one witness is enough to uphold the conviction. My submission is that. Let us see the cross-examination part of PW2. After my arrival at the place of occurrence, other people came there. The incident took place on a public road, and as such, around 100 people gathered there. From the neighboring people, Nasiruddin, Mojahidul Islam, and Habijur Laskar were present at the place of occurrence. It is not a marketplace, and there was no other shop except only one shop. The accused fled away from the place of occurrence as soon as he saw people gathering there. My house is situated at a distance of 150 meters from the national highway. It is not a fact that the place of occurrence is situated at a distance of 500 meters from the path of my house. There are other houses by the side of the path in between the place of occurrence and my house. Police recorded my statement on the date of occurrence at Lala police station. It is not a fact that I did not state before the police that I was on a national highway at a distance of 3-4 miles away from the place of occurrence. It is not a fact that I have stated falsely that I was on a national highway at a distance of 3-4 miles away from the place of occurrence. It is not a fact that I did not state before the police that I found Zakir Hussain coming from Lalachera in a bike and stopped near the pharmacy. It is not a fact that I have stated falsely that I found Zakir Hussain coming from Lalachera in a bike and stopped near the pharmacy. It is not a fact that I did not state before police that after the accused came out of the pharmacy and found my father alive, he gave more blows on the neck of my father, and as a result, my father died in a spot instantly. It is not a fact that I have stated falsely that thereafter the accused came out of the pharmacy and found my father alive. He gave more blows on the neck of my father, and as a result, my father died in a spot immediately, instantly. I did not inform police. My mother came to the place of occurrence not on the basis of my information, but after her arrival at the place of occurrence, I disclosed her about the incident. It is not a fact that I did not state before police then. Immediately after the incident, my mother, my brothers, and sisters came to the place of occurrence, and I told the entire incident to my mother. It is also not a fact that I have deposed falsely that immediately after the incident, my mother, my brothers, and sisters came to the place of occurrence, and I told the entire incident to my mother. After 4 or 5 minutes of the incident, the police came. The distance between the place of occurrence and the house of accused and Lalachera is around 2 kilometers. The Lala police station is at a distance of around 3 kilometers from the place of occurrence. I was there at the place of occurrence for 10-15 minutes after the police came. I accompanied my father with police to the Lala hospital and then to the Lala police station.
Accompanied the dead body.
Yes. My relative Nasiruddin Barbuya accompanied us to police station. I returned my home at 8 p.m. Thereafter, I did not meet police in connection to the case. One of my uncles, Altaf Hussain Laskar, took my uncle to SMCH, Silchar. I did not visit SMCH Silchar. It is not a fact that I have stated falsely that my uncle Islamuddin sustained cut injuries. I cannot say when and where the exhibit to Caesar list was prepared and what is written there on. I was not present the place of wherein the accused person was arrested. I did not see the place wherefrom the police seized the dhow. It is not a fact that I have stated falsely that the police seized dhow when the accused person was arrested. It is not a fact that I did not see the incident and I do not have any personal knowledge about the incident and I have deposed falsely. It is not a fact that I have deposed falsely that the accused murdered my father and assaulted my uncle in a pharmacy. This is his testimony before the court, my lord. Now I take your lordship to the evidence of PW10. This is the witness who is reliable, trustworthy, and lordship, whatever I stated seems to be lordship.
PW3.
PW 10.
Yeah.
Yes. Altaf Hussain Chaudhary. He is the
Who
owner
had
of
done
a
the, madam, who had done the inquest?
inquest, my lord. Inquest report, my lord.
This is done by police personnel. Police.
Inquest page 147.
Yeah, I think statements also.
47. Haider Hussain Laskar SI. Again, it is an anything. PW18. PW18. Yes, PW18, man.
He had done the inquest. Let us see the inquest report.
Lordship, it pays 147. Name and designation of the EMIO, Haider Hussain Laskar, or Lordship, whether his signature. Yes. Place and location where body is found. Joy Krishnapur, Soklapar, Western Side, NH 154. Position of the dead body lying underground upside. Date and time, a place of inquest, 26, 7 and 6 p.m. 5 p.m. The incident had taken place, Your Lordship. Date and time, when the inquest closed, 26, 7, 6:35 p.m. Whether relative of deceased informed, yes. Relationship of relative present during inquest, Rubul Hussain Laskar, son of Ali Uddin Laskar. Rubul Hussain Laskar is the PW2. Biodata of the deceased has been given, my lord. Name and investigation of police officer, SI Haider Hussain. Whether appears on the body any wound, deep cut mark on neck right side, fracture shoulder, any other mark, one cut mark on right neck and one on right shoulder. Lordship, then paragraph 16 number point. Part of the body region or part of the deceased not affected by any kind of injuries. One deep cut mark on right neck and one deep cut mark on right shoulder. Apparent cause of the death in opinion of EMIO, the deceased is murdered by accused Zakir Hussain Laskar according to witnesses.
Madam, see the PM report.
My lord, PM report at page 161. My lord.
Yes.
Lordship will see injury, my lord.
Yes.
Page 165.
Yes.
SC injury, maybe surgical cut injury over left side of
Yes.
throat.
Yes.
SC, I don't know, maybe surgical.
Yes.
Sharp cut. Sharp cut injury 10 AM to so and so over left eyeball containing left side of face.
Yes.
SCI 5 cm so and so over left parietal region of scalp.
So how is it corresponding with the
Inquest, my lord.
inquest 148 at page 16, 148, serial 16?
148, serial number 16.
No, right.
Right knee.
Left side of.
Yes.
Left side.
Inquest says all right side, because the specific question
Yes.
was put to this doctor who had conducted the PM.
Yes.
If you come to
Doctor
at serial
Yes.
number,
PW 15.
serial
No,
number
no,
at
P-
page 36.
PW 13.
Page, PW 13, page 36, 37. Kindly see in the cross examination.
I found all the injuries in the left side.
The left side of the disease. That is was specifically extracted from him. And this
Yes,
is in terms of the PM report also.
my lord.
Now, inquest says right side. There may be mistake in describing.
Lordship.
While describing, my right side can be the victim's left side.
Maybe, my lord.
So that
Lordship.
or that
It's a
happens
part
at times.
of the investigation, lordship.
Now, while
inquest.
describing,
My lord.
suppose
It's lying like that.
My lord.
On the right side of his neck, I see, but for the deceased, it will be on the left side.
My lord. So since he's an expert, lordship, be the doctor. Lordship, expert
Doctor
opinion.
determines more accurately.
Yes.
Because he has to
My
dissect.
lord. And this lordship, so his
Okay.
testimony.
No, we are not trying
My
to,
lord.
this may be some inadvertent mistake, in just not mistake, mistake in describing.
Lordship.
From the body is lying this, he may say on the right side of the body.
My lord.
But from the perspective of the body,
I
it will
know.
be on the left side of the
No.
body. Okay.
Now I take your lordship to the evidence of PW10, Altaf Hussain Chaudhary. I know accused Zakir Hussain on 26.
He's the owner of the
Yes.
pharmacy.
She was the natural witness. He is not related to anyone, my lord.
PW.
PW
10,
10.
29.
Yes.
I know the accused Zakir Hussain on 26/7/15 at about 5:30 p.m. while I was sitting in the veranda of my homeopathy shop at Abdullahpur Point 1, situated by the side of National Highway. I saw Alimuddin and Islamuddin, two brothers, were coming from southern direction towards my shop. When they came in front of my shop, the accused Zakir Hussain came from northern direction by riding a motorcycle and stopped near them and took out a dao of about 1 cubit length from his bike and attempted to assault his father Islamuddin, but his uncle Alimuddin came in the middle and by raising hands tried to resist the accused. Then the accused Zakir inflicted 3 numbers of dao blows at the head of his uncle Alimuddin. I, being alone, was helpless and started raising him and cry. Lordship will kindly note. Then his father entered into my homeopathy shop. The accused also entered into my shop. There was none present inside my shop at the relevant time except the accused and his father. As I was outside my shop, I did not see the accused assaulting his father, but since there was none present from the blood oozing injuries of his father, my strong belief is that it is the accused person who had assaulted his father with the same dao. When the accused came out from my shop after assaulting his father, his uncle was lying on the ground, keeping his face upwards, almost dead. And the accused again inflicted dao blow at his neck. His uncle Alimuddin died on the spot. By that time, many people gathered there and shifted Islamuddin, the father of accused, to the hospital. Police took the dead body of Alimuddin. Police seized a cloth screen and one white religious cap, having blood stained from my shop in my presence from the place of occurrence. Police also seized one pair of black color nylon sandal in my presence from the place of occurrence. All the seizures mentioned above have been made by so and so. Police took me to the court and my statement was recorded by magistrate. Exhibit 7 is a statement and so and so. Lordship, then his cross-examination. There was a
Let us see this 164,
164 of
PW10.
PW10, Altaf. Lordship, Altaf, page 159. 159. I don't know why it's written as victim. He's not the victim. Page 159. Has your lordship got
One of the injured persons who died during the trial.
Yes,
He is the own father, he's the father of the accused.
yes.
Accused.
Lordship, may I read? Around 5:30 p.m. on 26/7, I was sitting at my homeo clinic situated at Abdullahpur Part 2. Then I saw accused Zakir Hussain coming towards my shop by riding a motorbike. Islamuddin Laskar and Alimuddin Laskar were also coming on foot. Thereafter, I saw that Zakir Hussain stopped the bike, took out a dao from his bike, went in front of his father and attempted to assault him. Then Alimuddin tried to stop him with his hands, but Zakir assaulted Alimuddin on face. I came out shouting. Then Islamuddin came in a run and entered my homeo clinic. Zakir Hussain also entered my shop and assaulted Islamuddin on his face and hand with the dao. After the neighbors had arrived, we found that Islamuddin was still alive. He was taken to the hospital. After making the assault by by means of Zakir Hussain left the place of bye-bye. After coming out, as Zakir Hussain noticed that his uncle is still lying alive, he again assaulted him with the dao and left the place of. So Lordship, it's corroborative, Your Lordship, 164 statement. And his testimony could not be shaken, my lord. And he was taken to be a res gesti witness, Your Lordship, since it is contemporaneous, Your Lordship. Although he has not seen, he has stated that it was behind a screen, my lord. He has assumed that it is the one because there is no one except the accused and the victim.
This 164 is stated about.
Yes, my lord.
But there.
Yes, so Lordship, he is not related to anyone, my lord. His testimony could not be shaken, my lord. So his testimony can be taken into account.
He's
my
the
lord.
star witness of.
Yes, my lord. Not, I don't think the other witnesses, Lordship, are so important, Your Lordship. And probably I have, Lordship.
But this PW 10, either in his deposition or in his statement of 164, has not made any reference to PW 2,
Yes.
the presence of the son.
Yes, yes. Even the PW2's conduct, my lord, seems to be.
2 has said pharmacist was present.
Yes,
2 has said
Pharmacist
Yes.
has not said.
pharmacist has not corroborated
yes,
that he was also present.
yes.
But the presence of the pharmacist appears to be more natural
My lord,
because the place of occurrence is inside and outside the pharmacy,
my lord.
which is open. And his presence would be a natural situation.
My lord.
Hmm?
Lordship. Now, as regards the, this one, Lordship, GD entry, page 189. Receipt of information over phone entry and departure of CI and SI.
189.
Page 189. Although Lordship time mismatch, my lord, Lordship village people, there might be little bit of discrepancy as regards time, my lord, because they are on assumption gives the time, 5:10 PM. And this information has been received from someone from Jai Krishnapur, Sakalapara.
That is the place.
My lord, yes. Over phone that a person has killed his uncle by hacking him with dao at a place of occurrence and caused grievous injury to his father. Accordingly, an entry is made by SIM Islam along with SIH's Laskar CI Lala and staff move out of Sakalpara, that is the place of occurrence. Now I take your lordship to the evidence of IO, PW18. What step has it taken on the basis of GD entry, your lordship? PW18.
Mr. Majumdar had contended that no person was named in the GDN.
May not be,
If
my
you
lord.
see, it was given by someone.
Someone.
Maybe someone from the crowd also.
Yes, my lord. So it should not be a
May
cryptic,
not-
my lord. TT Anton is clear to that effect, my
He
lord.
has a point, but.
Lordship,
we
my
can
lord.
have side.
PW18, my lord. Page 48. On 26/7/15, I was posted at Lala PS. And on that day at about 5:10 PM, the then OC of PS received an information accordingly. Lala PS GD entry 625 dated 26/15 was registered. I was asked to take step and accordingly I started my investigation. During investigation, I visited the place of occurrence, drew a rough sketch map thereof. I found victim Alimuddin Laskar and sent him to hospital for medical treatment, but later on, the said person expired. The inquest on the dead body was done by me. Thereafter, the dead body was sent for the PM examination and accordingly, I collected the PM report. I examined the witnesses and also got the statements of a few witnesses, namely Altaf Hussain Chaudhary, Sainara Begum, recorded in 164 CRPC. I also seized one dao, a nylon rope, one bloodstained cap, white color curtain, and also one motorcycle bearing so and so. And accordingly, those articles were seized. The seized 6 numbers of articles, that is one Genji Lungi Punjabi shirt, ash color cloth, white color cap, one wooden handle dao, and all the articles were sustained with suspected human blood, were sent to FSL for chemical examination, and accordingly, the report was collected. One victim, namely Islamuddin Laskar, was sent for medical examination, and accordingly, his medical report was collected by me. I also collected a PM report and a statement of the witnesses under section 164 CRPC. I arrested the accused and thereafter sent the accused for recording his confessional statement before the magistrate, and accordingly, the confessional statement was recorded and I collected the said statement. Thereafter, on completion of the investigation, I submitted a charge sheet along against the accused person. Exhibit 1 is the inquest report, where Exhibit 1, 2 is my signature. Exhibit 2, 3, 4, 5 are the seizure list in respect of seizure of bloodstain articles. Exhibit so and so is the sketch map, and Exhibit P13 is my signature. Exhibit P14 is a charge sheet wherein so and so. I examined witnesses on Altaf Hussain Laskar, and in his evidence, he stated that his brother Zakir Hussain, in order to kill his father, caused grievous injuries on his body by means of a dao, and also kill his uncle Alimuddin. In the GD entry, there is no specific name of the accused. There is no mention as to who gave the information to the OC for recording GD entry. Exhibit A is a relevant GD entry which was recorded by the then OC of PS. The FIR was received by OC so and so. In the scissor list, may I read? Don't have to read probably, Father. Lordship, whether this one, my lord, PW10, what he stated before the highlighted chief file. Nothing has been imposed as regards the evidence given by PW10, your lordship, in the cross-examination part. I didn't find that. 6, 7, 15. So my responsible submission is that since on the basis of the GD entry, the investigation has progressed well. So subsequent FIR can be lordship treated as lordship the 161 statement, your lordship. In terms of lordship TT and Tony. It can be as cryptic information, received by police. So when eyewitness's account is there, PW10, lordship, he is lordship consistent throughout, your lordship. So in that event of the matter, lordship, in the case of eyewitness's account, my respectful submission is the motive is not a crucial part. Although this one, 164 statement has been discarded by the learned trial court, your lordship. Lordship, on taking into account the evidence given by PW10, your lordship. Since from his statement, nothing could be discerned as regards motive, your lordship. So my respectful submission is that motive is not an important sine qua non in case of eyewitnesses account.
But still.
Okay, point, sir. Lordship has any specific query, my lord?
We had asked certain questions to Mr. Mazumdar yesterday. You can also answer
My
those.
lord,
First, the recovery of the bike.
my lord.
Why we are asking? Because there is a consistent version that he fled away with the bike.
Yes.
And we have also found some deposition where it has been stated that the bike has been recovered, seized from the place of occurrence.
Yes, my lord.
That is one. Number two, the recovery of the dhow.
My lord,
He had fled along with the dhow.
my lord,
Dhow has been recovered and seized not from his house, but from the house of another person.
my lord,
And it was in a locked house. The door had to be almost broken. Then it was found beneath the bed,
my lord,
His brother's house.
my lord,
his brother's house.
lordship,
The dhow was found to be bloodstained.
my lord.
Blood was also found to be that of human, but there was no further matching. So, but
Only
that,
contained
but
in book,
yes.
not contained of.
Matching is most important.
Yes.
but that by itself may not make the entire
My
case
lord,
fatal
my lord.
for the prosecution. But if you are seen to be fleeing from the place of incident in the motorcycle, how did you recover the motorcycle in the place of
Lordship,
occurrence?
let us see the evidence of PW.
We come back.
Lordship, although PW 3 and PW 6 are two Caesar witnesses as regards motorcycle, PW 3 doesn't say anything as regards the Caesar, your lordship. PW 6, let us see, my lord. PW 6. Six or something.
No, 6. Quick see.
A police sees lordship page 23. A motorcycle belonged to the accused from the place of occurrence in my presence.
In my presence.
In my presence.
And see the scissor list itself.
Yes, my lord. Let us see the sketch, my lord.
Now, see the scissor list.
Scissor list. Scissor list as regards motorcycle is page 157. One motorcycle bearing so and so, black and so color.
No. See, place.
Lying on the house of Jahangir Laskar,
Yes.
Tuku. Jai Krishnapur Saklapur.
Who is PW3?
Lordship, let us see from the sketch map whether the residence of PW3, my lord. Let us see the evidence of PW3 was, where he is situated.
So there's some discrepancy about Caesar, place of Caesar of the motorcycle.
Yes, my lord, but lordship, let us see. He is a lordship, paralytic person. I know the accused person, Jakir Hussain. I know the informant, Aklima. She is my aunt. The accused is my related brother. On 26/7 at 5 p.m., I was in my residence, which is around 5 meters, 500 meters from the place of occurrence. I am a paralyzed person and could not walk without any support. At a relevant time, I was paralyzed. At a relevant time, I heard hue and cry coming from the old house of the accused person. At a relevant time, it is in the old house of the accused person, his brother Altaf Hussain and other family used to reside, but the accused reside in different place. Altaf Hussain came to my house immediately and told me that his father Islamuddin, Uncle Alimuddin were murdered. Then I boarded the auto rickshaw and went to the place of occurrence. My lord. Just see the sketch map, page 181.
Sketch map will give you nothing. Nothing is there. No houses adjacent, nothing has been shown.
Moreover, lordship, motorcycle was seized on the following day, not on the date of the occurrence. Yeah, and that is on 27.
Maybe taken as an omission, my lord, on the part. If your lordship permits, may I see the?
Yes, please do.
This is around the subsequent. This police officer, date of Caesar.
Date of the,
Caesar, Caesar.
27. 27/7/50.
I know the becomes 164 is also there, but has it been executed?
Russian, I need to see.
It is there.
90.
Lordship, it was of 27/7. It is learned that the accused Zakir Hussain had left his motorcycle on the house part of one Jahangir Laskar of Jaykrishnapur after commission of the crime. Hence, I now left a PO along with staff towards house of Jahangir Laskar to seize the bike in connection with the case. I now arrive at the house with the Jahangir Laskar along with staff, and I found motorcycle bearing so and so number is lying on the path. Accordingly, I seized the same in presence of the witnesses as per Caesar list. It is of 27/7.
But PW6, who is one of the witnesses?
Why not?
PW6, so far as the motorcycle is concerned,
Huh?
he is one of the witnesses
Why not?
for the seizure of the motorcycle.
Yes.
At page 23, it starts at page 22. At page 23,
My lord, page 22.
23, last sentence of the chief examination.
Yes. Police also seized.
Seized a motorcycle belonged to the accused from the place of occurrence in my presence.
That is
Discrepancy
not
as
other-
regards.
Other facts. No, supported by the-
Now, sketch map also does not give an idea
My lord.
whether the place of occurrence and the place from where the seizure has actually been made are in proximity.
My lord.
It may
But
be,
it is on the highway, your lordship, and as I have
no,
gone
it
through
is
the.
not on the highway. He says on the pathway of one person. Seizure list
Yes,
itself says,
PW
if you come to the seizure list at page 157,
7.
I think, of the motorcycle,
157. My lord.
at page 157, the last sentence, seizure is made today at 27/7/15 at village Joy Krishnapur in the presence of undersigned. Just go 2 lines above that.
My lord.
Was found lying on the house path of Jahangir Laskar.
Jahangir Laskar, PW3.
House path of Jahangir Laskar.
Yes. Which was used by so it was like lying abandoned, your lordship.
But he says place of occurrence. PW3, what does PW3 says about the seizure?
PW3.
PW3 does not say
Doesn't say
anything about the seizure of the motorcycle. Rather, he says the seizure of those items which were kept in a box.
My lord.
Material exhibit. If you come to page 17,
My lord.
just before the cross-examination starts, the dead body of Alim was taken by police seized in my presence.
My lord.
Have you got last sentence of 17 before the cross starts? 5 lines, 6 lines.
Police seized in my presence one
One
blasting.
blastin, so and so, so and so. These are all exhibit 2 and material exhibit. It's in a box.
Yes.
He doesn't say anything about the motorcycle.
Motorcycle.
Though his signature appears in the seizure list of the motorcycle at 157.
On the main record, possible to check whether the Saniara Begum's 164 has been exhibited.
Lordship, Saniara Begum.
From the paper book, it does not seem so. From there, we'll be able to make it.
Lordship, I'll see. Yes, put here record to dear.
Index is not.
Lordship, I'll see. It's there, page 190.
It is there.
My
Is it
lord,
exhi-
or whether it is exhibited, lordship.
It is not given. Altaf Hussein's statement is exhibited as exhibit 7.
My lord, I'll see.
But here it is not, exhibit number is not given. Recovery of the Dow is more crucial than the
Lordship.
recovery of the motor.
My lord.
Never.
PW. Final.
No, 5.
This is 60.
21.
Lordship, it doesn't mention anything. The original exhibit doesn't say anything as about, it's on the exhibit, this one only, file A, my lord.
But not
Not-
indicated whether it is.
Yes,
exhibited.
my lord, it's
Probably
not
not
there.
exhibited. during that time.
My lord. But the list of exhibits is there.
It is there.
Yes,
I see. As exhibit number,
my lord.
this list of exhibits.
Oh, from 66 to 80 is written as such,
Oh, actually. Yeah. Probably not.
along with exhibited documents, it's written as such, and it is at page 74. Diok na bhai,
Probably it is not.
like. Signature is also there. Ek minute, Rupa.
Because her 164 statement is much more
My lord.
specific and
Yes.
significant than her deposition. Deposition,
Yes.
she has only stated about police seized and I gave a signature.
Yes.
But in the 164 statement, she stated that her brother-in-law came, left the dog.
Yes.
Later police came, they gave the dog.
Yes,
And after the leaving the dog, he fled away.
yes.
That is what.
Vishal Mesa signature is also there.
Yeah.
Yes.
It has been executed.
I have flag mark, my lord.
It was important to exhibit it.
Yes. Rashid has got any other query? Ma'am? Excellent.
According to you, PW 10 is fully reliable.
Yes, my lord. Lordship, let us see the place of occurrence, my place of occurrence. Joy Krishnapur, Sokalapar PS Lala. District Hailakandi.
I will ask. Better, since writing code proof for an produce for an particularly down.
Material exhibit. Material exhibit.
You can go to show from material exhibit.
Please,
I'll just try to see whether the place of occurrence as well as the rest, this one, the residence of PW6, my lord, which as regards the recovery. Lordship, may I see it's on the same.
yes. Madam, one
My
more
lord.
respect of the, regarding the seizure of the DAO.
My lord,
First, before we come to the witness, the IU,
my lord,
at page 48, we again refresh ourselves with the 164 of PW 5.
PW5, Serena Begum Borpuya,
Yes.
is 190.
Yes.
Yes.
Okay.
Around 5:36 PM.
At page 190, okay.
Lordship.
Yes, please wait. It's a very small one.
5:36 PM on 26/7/15, my brother-in-law, Zakir Hussain, came to our house and kept a dog. Thereafter, police also came to our house. We showed them the place where the dog was kept.
Okay. That means Sainara had shown the police
Yes.
where the DAO was kept.
Yes.
Now let us come to the IU. Okay.
IU.
IU at page
PW
48.
Yes.
PW 18.
Yes.
IU. At page 49. Page 49.
one wooden handled dowel.
Just a very innocuous statement that he had seized
Yes.
uh,
6 numbers of articles,
6 numbers of articles.
one wooden handled dowel. And so,
In respect of seizure list, yes, ma'am, just a minute, where are you getting wooden handed down? And I don't know, one dow, it is simply one dow, I also seized one dow. Page 49 plus first line. He says one dow. Okay,
Thereafter he repeats.
repeat.
These 6 numbers of articles, that is one Genji,
Oh, okay.
Punjabi shirt.
Okay, there is no further description of from where. Okay, let us proceed to the cross-examination part. Okay,
Yes.
okay, cross-examination page 50. Second paragraph. In the seizure list, there is no mention about the recovery of the dhow from the possession of the accused.
Yes.
Okay, doesn't matter.
Yes.
Please go. Then he took the dhow to the police captain, police Malkhana. We are not connected. We are not concerned with this at this moment. What we are trying to show it to you. Please, please keep on proceeding. You come to page 54. 54.
Yes.
54. From the first we'll read, okay? Thereafter police came, so and so. We read from 53, the last paragraph.
Yes.
It is not a fact that PW 15, Yahia Madhurvia did not state before me that on the 11th day at about 2:30 p.m. while he was returning home from the market on the ground at near Sakola Degree Park, he found a gathering of people and found one Ali Muddin was lying on the ground on the so-and-so. And along with police, he came to the house of so-and-so, where they found one of the houses was under lock and key, and under instruction of police, people broke open the door of the house and police asked him to enter inside the room. Accordingly, he entered along with the police inside the room, but he did not find anybody, but they noticed that one dhow was lying beneath the bed.
Inconsistent with the
Wholly
statement.
inconsistent.
Only.
He denies this, but that was the statement which was recorded in 161. Therefore, this witness was confronted with this. That means 1 PW 15 in his police statement had said that the house was broken, it was found beneath.
They went to the house of his brother Altaf Hussain.
Lordship.
In here it's broken, where they found one of the houses.
Yes. Yahina Majid, PW.
That means it might indicate that it may be a cluster.
My
Suppose
lord.
one house is there.
Or maybe a room also.
That was broken open.
One of the witnesses also stated that a lock was break and then entered. And on the other hand, in the 164 statement of Sainara, it is stated that she handed over the dhow. So there is a contradiction.
164, she did not say handed over. Come to page 190 again. 190 again. We showed them the place where the dhow was kept. Not handing over. We showed at page 190, the second last line.
Lordship.
Lordship. Sainara Begum Barbhuya, wife of Altaf Hussain Laskar. And what was this one? Yahia, PW 15. PW 15, my lord. Name differs.
This part is incompatible. That one is breaking open and
Yes.
one is she showed.
Yes,
Breaking open indicates that it was kind of hidden.
my lord,
They broke open, saw
my lord,
took it.
my lord.
Because in 164, she does not only confine to the aspect of showing, she says that brother-in-law came to her house, kept the dhow.
Yes.
She knows about it. Thereafter, police came. We showed them the place of where the dhow was kept.
Yes, sir. That's why I was asking you whether it has an exhibit,
My lord,
whether it has been exhibited.
exhibited,
Exhibit number is also not there.
not
It's not there. That's why they have not been
lordship,
written in the papers.
my lord.
It's not clear, but magistrate signature would not be there. It is just seen signature or
Seal, sign and seal
exhibit
is there. not exhibit signature.
Only seal.
Yes.
Seal.
Seal of the magistrate is there.
So I think may not be exhibited.
My
After
lord.
exhibition is
Lordship.
there, so-
But it's in the bunch, my lord, it's in the
Because
exhibited
after the
documents.
164 recorded magistrate signs.
My lord.
Right.
Maybe,
Exhibiting is different. Exhibiting will be the signature of the session judge.
yes.
Probably not exhibited, but it should, but it was a very important document to be exhibited. I witnessed the things on the road. I can do.
Lordship.
I have the question whether it will be relied upon.
Procedural irregularities are there, your lordship, lapses in the prosecution. Whether it is fatal, has not affect the core of the prosecution case, your lordship. In 313 also, the accused person has remained silent, your lordship. He has not stated anything. Go on, right? 313.
He denied the policy petition.
Confession was not accepted.
My lord.
Police remand-
I don't know why the learned,
No, because we are in police remand.
yes,
From police
yes.
remand, I don't think you accept.
Yes, your lordship, it
It has
was
to be
like,
sent back, has to be.
yes, against you, yes,
Transferred to JC
my lord,
and then brought back
my lord,
and then recorded.
yes,
No recording of confession from PC.
yes. I don't know why he was given into the custody of the SI, PSI.
No, he has to. Further, I know only from JC.
Yes, your lordship, yes.
That's correct.
Reflection time, everything was given, but again he was handed over to,
No.
No reflection time was given.
yes, the,
And he was only given reflection time in the PSI office. In the PSI,
no, no, lordship.
in the PSI office.
Although the learned trial judge has discarded it, lordship, may I take it to
PSI
the
office only,
page 170, your
the
lordship?
PSI. And then he brought back again. He was brought again and recorded.
Now,
Let
where,
us see the evidence of PW.
madam, where was he taken to for the confession? Was he in the police remand or police custody or judicial custody?
Let us see once
Yes.
again, please. The evidence of PW 16. Gypsy Das.
Let us see the discussion of the learned judge, case at para 77 or
73, that
73.
lordship.
Easy. He's produced from after arrest from he was in police room. He was given to PSI person. That will not be.
Yes, I have given 5 hours reflection time. That part is okay. And since the offense alleged to have been committed under so and so, I gave him to the custody of so and so. So subsequently, he was given into the custody of PSI.
No, he has to be given to JC.
Yes, your
prior.
lordship, that's the wrong he has
Judicial
committed,
custody.
my
He
lord.
has to go to the jail.
Yes, your lordship.
Will stay there, then brought back.
So
That-
refreshing time was not
Okay,
given.
reflection time 5
No
was given.
refreshing time was given totally. That's why
Reflection time, even if it is given.
It was given, then subsequently it is given to into the hands of PSI. That is inadmissible.
Police only.
Yes. So entire evidence, lordship, 166 statement goes now. Other stipulations have been followed, your lordship, while recording the confession, except that part, your lordship, which is inadmissible.
follow.
Others follow.
Others.
Stipulation as admissible in the.
See, this,
Whatever could do.
madam, this Yajila, PW 15,
My lord,
who was, in respect of whom the cross-examination was done to the IO at
Yeah.
page 53.
yes.
If we read her statement, deposition at page 41,
40, my lord,
41. 41 is PW 15, neighbor.
Yes.
Please come to 41.
is 41,
Page 41.
yes,
First, she was not required to say the time if she was not very confident. She
Yes.
says the time is 2:30 p.m.
yes,
5:30, 6:30, then 4:30 is okay. 5:30 can be 4:30, can be 4. It says 2:30, number one. But let us go further. While I was returning home from market on the way to so-and-so, I found gathering of people and saw one Ali Muddin was found lying on the ground with cut injuries on the neck. Thereafter, people came
police
and
came,
police came and along with me went to the house of the brother of the accused, namely Altaf Hussain, where we found one of the houses under lock and key.
yes,
Then, under the instruction of police, people had broken the door of the house and police asked me to enter inside. Accordingly, I entered inside along with police but did not find any person. Then we noticed one dhow lying beneath a bed, which the police seized in my presence.
my lord, worship. 2:30,
Somebody says that he has shown the dhow and it was
This is not compatible with the version of the 164 statement of Sanyara Begum.
yes, worship, true,
Sainara.
My lord.
And probably that is why the learned prosecutor did not exhibit.
my lord, maybe, lordship. 2:30 up to 3 hours, lordship is stretching. Village people, my lord, they don't have so
and this
much of
PW 15 says the dhow was very much clean, but you said that the dhow was stained with blood.
blood.
It's a different matter. Apart from saying that it's human blood, no further matching was done. But PW 15 says it was clean.
That is also like peculiar conduct.
Yes, my lord, that was very
Keeping
much
a
clean,
blood after the incident, keeping a
Lordship.
blood stain down in
Yes, Lord.
someone's house
my lord.
instead of trying to hide it.
That too, locked house,
You must have locked it
My lord.
even if someone had kept it. Standard conduct. Otherwise, cannot be done.
Lordship, may I cite certain judgments
Regarding
regarding this one, whether GD&T can be, lordship, if the cryptic information is unlisted.
that we are not accepted what Mr. You can cite you if you want to. What is it?
TT Antonio, lordship, TT Antonio.
And you treat it as 161 statement. That
Yes.
cannot be two FIRs.
Yes,
That
my
is a settled position.
Yes.
Please give the citation. TT and
2001.
You giving the copy or?
Yeah.
Okay.
2001.
SC 2637, there are 19 of them.
Judgment of price, I mean, some
On confession, my lord?
cryptic telephonic information
Yes,
initially. And then what happens? So it's a many a situation, many a time this thing happens.
my lord,
Somebody informs on phone,
my lord. Lordship.
many information.
And contents of FI and GD, lordship, may I refer State of UP versus Naresh, 2011 4 assistant.
And this Anthony is which paragraph?
Lordship, 19.
Nowadays, this aspect will be very common
My lord.
because everybody has a phone in that.
Lordship.
The moment there's an incident, there will be a telephone.
Inform, yes,
Most many cases, or probably most cases, this kind of things,
Right.
this telephonic information, brief
Right.
telephonic information will come.
my.
The entire purpose, the objective of TT Anthony, which we understand, is not to harass a person for the same offense twice. So any other subsequent information can be treated to be 161. And it is more required at the initial stage of the investigation when a person might require to approach a court for bail. If he gets the bail in one of the cases, then on the same offense, another case, seeking bail will be a mere harassment. So that is the purpose. That's any subsequent information you treat as 161, but you cannot have two cases registered. That is the objective.
And on the basis of GD, the police proceeded well, Your
Yes.
Lordship, well with the
And
investigation.
for that, he is not suffering any prejudice. It has to be tested from the perspective of what prejudice has he suffered while adducing his defense, while preparing his defense. He has not suffered any prejudice.
Only thing is that, if the GD entry is taken as the first information.
Yes.
Filed,
Yes,
then the formal FIR can only be used for contradiction.
yes, my lord,
That is the question.
my lord,
Otherwise, it's not,
Lordship,
it can no longer be used as proposition.
yes,
For
my-
proposition.
yes,
Because if it is treated as a 161.
Lordship,
So that is why,
my lord.
what would constitute, can be taken as an FIR? First in point of time, yes,
My lord.
definitely, the GD entry.
Lordship,
But it is not a formal FIR, no doubt about it.
Yes, what is the next one you are trying to?
next one, delay
No, no.
of my learned from a site.
Yes,
I did not cite.
CWP was for what?
It's a contents of the FIR, para 32.
But GD entry only the GD entry will be the. FIR.
Yes,
It
Lordship,
will be, cannot be used for.
my lord.
proposition.
Lordship, para 32. It is a settled legal proposition that an FI is not an encyclopedia of the entire case. It may not and need not contain all the details. Naming of the accused therein may be important, but not naming of the accused in FIR may not be a ground to doubt the contents thereof in case the statement of the witness is found to be trustworthy. The court has to determine, after examining the entire factual scenario, whether a person has participated in a crime or has firstly been implicated. The informant, fully acquainted with the facts, may lack necessary skill or ability to reproduce details of the entire incident without anything missing from this. Some people may miss even the most important details in narration. Therefore, in case the informant fails to name a particular accused in a FIR, this ground alone cannot tilt the balance of the case in favor of the accused. Right, so and so. Lordship, that much I have to rely on. Want to listen to the delay.
He took a point of delay of 6 hours.
Yes, under.
We have not accepted.
Yes, but I will refer one judgment on that.
6 hours, how can 6 hours in a murder case be a?
Ravinder Kumar. Lordship,
And that's a
Ravinder-
FIR lost by the wife. We do.
And one of the victim was seriously injured.
Yes, my lord.
He was taken to the
Ravinder
hospital.
Kumar and another was a state of Punjab. Era 13 onwards. To attack on prosecution cases on the ground of delay in lodging a FIR has almost walked down as a stereotype redundancy in criminal cases. It is a recurring feature in most of the criminal cases that there would be some delay in furnishing the first information to the police. It is to be remembered that law has not fixed any time for lodging the FIR. Hence, the delayed FIR is not illegal. Of course, a prompt and immediate lodging of the FIR is ideal, as that would give the prosecution a twin advantage. First is that it affords commencement of the investigation without any time lapse. Second is that it expels the opportunity for any possible concoction of a false version. Barring these 2+ points for promptly lodged FIR, the demerits of the delayed FIR cannot operate as fatal to the prosecution case. It cannot be overlooked that even a promptly lodged FIR is not an unreserved guarantee for the genuineness of the version incorporated therein. When there is criticism on the ground of FIR in a case was delayed, the court has to look at a reason why there was such a delay. There can be a variety of genuine causes for FIR lodgement to get delayed. Rural people might be ignorant of the need for informing the police of a crime without a lapse of time. This kind of unconversantness is not too uncommon among urban people also. They might not immediately think of going to the police station. Another possibility is due to lack of adequate transport facilities for the informers to reach the police station. The third, which is a quite common bearing, is that the kith and kin of the deceased might take some appreciable time to regain a certain level of tranquility of mind or sedativeness of temper for moving to the police station for the purpose of furnishing the requisite information. Yet another cause is the person who are supposed to give the information themselves could not be so physically impaired that police had to reach them on getting some nebulous information about the incident.
Paragraph 15.
15.
15.
Yes. Then para 15. We are not providing an exhaustive catalogue of instances which could cause delay in lodging the FIR. Our effort is to try to point out that the still demand made in the criminal courts to treat the FIR vitiated merely on the ground of delay in the lodgement cannot be approved as legal corollary. In any case where there is delay in making the FIR, the court is to look at the causes for it, and if such causes are not attributable to any effort to concoct a version, no consequence shall be attached to the mere delay in lodging the FIR. Then it is well settled that the delay in giving the FIR by itself cannot be a ground to doubt the prosecution case. Knowing the Indian conditions as they are, we cannot expect these villagers to rush to the police station immediately after the occurrence. Human nature as it is, the kith and kin who have witnessed the occurrence cannot be expected to act mechanically with all the promptitude in giving the report to the police. At times, being grief-stricken because of the calamity, it may not immediately occur to them that they should give a report. After all, it is but natural in these circumstances for them to take some time to go to the police station for giving the report. Lordship?
In fact, Mr. Mazumdar, yesterday we were just discussing, if the FIR is lodged immediately, it might be counterproductive. At least as if it was premeditated. You go to commit the offense, and in the meantime, I lodged the FIR. As if she apprehended, she knew about it. 6 hours is not a delay.
But in the present case, Lordship,
6 hours is not a delay. Don't try.
I'm not pressing on this point.
In a given case, you may urge, but here in a case where
What is the delay?
what is
If
the
there is a delay, then explanation.
and what is the circumstance which my brother had pointed out? Circumstance of lady had lost her husband. One person is grievously injured. He was taken to the hospital. He was battling for his life. 6 hours, we think it's a very promptitude, not to talk about any delay. And if you want an FIR to be lodged in 5 minutes of an instance of this nature, it will be counterproductive. The doubt will go on the informant. How did you know this is going to happen?
Like, for example, if an incident is described with mathematical precision, because it can create some doubts. Because human nature is not like that. We are not robots.
Lordship, on the point of registry, I think section 6 is.
Register is not required here. There are 2 eyewitnesses, and in fact, register may not even come in so far as that witness is coming. He has seen it.
Yes.
It's
Eyewitness
not
at the
based
same
on
time,
any.
res gestae, he can be taken as an res gestae witness, Lordship. Part of same transaction, yes.
Okay.
Lordship, that is my responsibility. The prosecution could prove the case beyond reasonable doubt.
Mr. Madhumra, anything?
Lordship, I have some citation later.
Which one? Yesterday's?
No.
Citation regarding what?
Lordship, naming of the eyewitnesses. Lordship, para 42, 43.
After this Naresh has been cited, why is it required?
Lordship, para 42, kindly have a look.
2024.
Lordship, it is
INSC.
judgment dated 8th of this.
No, we've got neutral here. INSC, he is there, 1399. Govind Mandavi.
Lordship. Eyewitness naam kya yaar hotia.
Paragraph?
Paragraph Lordship 42, 43 and 44. December.
The accused should be named in the FIR.
No, Lord, eyewitnesses.
Eyewitness should be named in.
These are, I mean, the more information has.
When the informant is a close one and he is aware of that fact. In that
Okay.
event, it is required. Here in our case, Lordship, she is aware that these are the person her son stated to her. So she ought to have stated such fact in the Azahar. Lordship, may I read these three
But I'm
paragraphs?
totally relying on the evidence of PW10. Is no way connected with either side.
No, he's
PW10,
Lordship, and
independent witness, natural witness, your Lordship.
and again also Lordship on that point, another judgment. It is reported case Lordship 2013 Criminal Law Journal 3140 para 16.
2013.
Para 2013 Criminal Law Journal 3140 Supreme Court. Para Lordship 16. And the last Lordship, this.
This is for what purpose?
It is for recovery,
3140?
recovery, doubtful. That is here in our case, Lordship.
Paragraph?
Paragraph Lordship 15.
15.
Lordship. Last one is
No, Sujit is 15, paragraph 15.
Lordship.
Sujit Biswas. 13140 is paragraph 15.
Lordship one.
And
Go on.
Kashiram is.
3140 Lordship paragraph 16.
16.
And 2006 12 SCC. It is para 15.
2006, 12.
SCC.
Page?
Page 254.
Para?
Para 15. State of Rajasthan versus Kashiram.
15.
Lordship.
What is the proposition?
Proposition recovery is doubtful if the seized ITM is not produced before the court.
That is in case of circumstantial evidence. When eyewitness's account is there, your Lordship, when the evidence
And
that witness could not be demolished, my lord.
Circumstantial evidence is very challenging always.
And moreover, Lordship, discovery of thou is not the result of the disclosure made by the accused.
That is not their case. 27, they have not brought in
No,
27.
Lordship. And moreover, it is also not proved, there is no scientific evidence that fingerprint with the accused has
To
match.
help the prosecution, actually, it has to be proved that the weapon is the weapon of offense.
And so far as recovery of bike, it is very much contradictory. So, Lordship, it may go, and confessional statement already learned trial court discarded. I am not pressing that. And so far as eyewitness part, Lordship, PW10, my submission is not a reliable, Lordship. PW12 stated that he was not found the PW pharmacist in the place of occurrence. In his cross, he has admitted,
PW12.
Lordship. And PW11 admitted that there is so many other shops in the nearby place of occurrence. but that neither are not examined. Only PW10, who is the friend of the lordship informant son, that is the PW2, he was examined. In his cross, he was suggested, PW10 was suggested that you are the friend of the deceased son. That's why, but he denied. So that aspect lordship may consider. I leave it to your lordship.
Lordship, page 29, PW10 is specific, there was dog identification. I know the accused Zakir Hussain, and in his lordship, page 32, second paragraph, fourth line, I have no relation as well as enmity with the accused and his family members, including the deceased.
Okay, we'll close it, huh?
Otherwise,
Did you see him?
I saw him junior, but
Okay, Mr. Jain was there.
he was there. In fact,
Okay, we'll record his name. Same
Same
order, huh? Oh.
model.
Then you write K. Jain on behalf of Sri S.C. Kyle, Senior Standing Counsel, CGST, and Sandilla, A. Sandilla. Same order. Yeah. Have you seen, checked yesterday's order?
I checked.
Is it okay?
Yes,
Same.
Same.
K. Jain. If Mr. Kyle comes, just inform us. We'll try to record his name. But Mr. Jain was there, we can record his name.
He was there. In fact, I heard him speaking on the phone and informing that the court will sit in Central.
Just see if he's there outside. Okay.